A proposed law that could change how Kenyans report wrongdoing is now before Parliament. The Whistleblower Protection Bill 2025 seeks to give legal cover to anyone who exposes corruption, misuse of public funds, or any conduct that goes against the public interest. Faith Wangari has the details.
For years, Kenyans who have spoken out against wrongdoing in public and private institutions have done so at a great personal risk, facing dismissal, harassment, and, in some cases, threats to their lives. The Whistleblower Protection Bill 2025, introduced by Attorney General Dorcas Oduor, now seeks to change that.
When you look at the legislation in place, the policies in place, the institutional framework, but even culturally, whistleblowers don't have that much support. So we really need to put that commitment, as we have signed in the African Union Convention for Preventing and Combating Corruption, as we have signed our commitments in the United Nations Convention Against Corruption, that as countries will put in place measures to protect whistleblowing.
The bill applies to public entities, private entities, NGOs, and faith-based organizations. It covers a wide range of individuals, including civil servants, private sectors, employees, contractors, volunteers, and even members of the public who come across information relating to improper conduct. The conduct that can be reported is broad. It ranges from bribery and corruption to gross mismanagement of public funds, violations of human rights, and any act of omission that creates a danger of life, health, safety, or the environment. Critically, a whistleblower does not need to prove the wrongdoing. They only need to reasonably believe that it has occurred, is occurring, or is likely to occur. Once a disclosure is made, the bill guarantees whistleblowers a range of protections. No employer may dismiss, demote, suspend, transfer, harass, or threaten a person for making a public interest disclosure. Contractors cannot be terminated or withheld on that basis either. Where a whistleblower's life or safety is determined to be at risk, the Commission is required to refer the matter to the Witness Protection Agency. Making a disclosure is designed to be accessible. A whistleblower may report orally or in writing, and anonymous reports are expressly permitted. Reports can be made to a supervisor, a designated officer within an organization, or directly to the Commission on Administrative Justice. Once received, the designated officer is required to forward a copy of the report to the Commission within 14 working days.
And let's breathe life into those commitments and actually ensure that we have legislation, but beyond the legislation, that we actually implement the provisions to ensure that anyone who comes out to report cases of corruption or other forms of wrongdoing is adequately protected.
The Commission on Administrative Justice sits at the center of the proposed framework. It will receive and investigate disclosures, handle complaints of retaliation, coordinate with enforcement agencies, and conduct public awareness campaigns aimed at fostering a culture of accountability and reporting.
I find that there's very little political goodwill, but we must push and hold our political class to account, particularly the members of Parliament.
The bill also introduces a provision that has largely been absent from Kenya's legal landscape, a whistleblower reward scheme. Public and private entities will be permitted to establish programs that financially compensate whistleblowers whose disclosure lead to detection, prevention, or prosecution of improper conduct. Faith Wangari, TV 47.
In other news,